Hey, aloha everybody. Welcome to the Questionable Authority where, wow, that pegged red right off the bat. Sorry guys, since the last stream I have a new computer, new webcam, which appears to suck, but, I'll work on getting it to be a little bit better a little bit later. And, generally speaking, it's just a delight. It's absolutely just a delight. But anyway, welcome to the Questionable Authority. It's a multiple time a week. No, it's a single time a week Twitch stream. I know I look sunburned. I'm not sunburned. I just have really sucky color balance, which is funny because it's the Mark II version of the Mark I that broke. And it's a decent camera. I just need to learn how to fuck with the settings. Pardon my French. Anyway, my name is Mike. I'm a commercial litigator with Cameraman Unsick, Sonecker, and Klein in New York. I am a lawyer, in other words, but I am not your lawyer. Unless, of course, I am your lawyer. And if I am your lawyer, we've had this conversation. We have definitely had this conversation. So just keep that conversation in mind. Doggo, do you want to make an appearance? You want to come say hi to the people? I heard you coming when you heard me starting to talk. Yeah, pop up. Who's a good girl? We've got a new box, but it looks just like the old box. So the people moved. The people are in the new box now. But the new box is in the same place, so you shouldn't be too confused, should you? You shouldn't be too confused. Oh, go away. Oh, good girl. Yes, you're a good, sweet girl. Stay out of the... No Tootsie Rolls. No Tootsie Rolls. Anyway, also, the crap that's by the trash can, the kitten pulled out of it over the course of the day. Gotta love animals. Maybe I should just go to, the older camera, which sucks less. Apparently the older camera sucks less now. There we go. Anyway, and yes, give you a view of the areas you don't usually see, right? So yeah, Mike, lawyer, not your lawyer. Those are the major rules to keep in mind here. Beyond that, you guys got questions about law stuff that's not related to our stream topic, now's a good time. I just have to remember to look this way. See, I'm not that sunburned. But yeah. I'll get that one working eventually, probably. Should you break the law? I think Jim Carrey's advice when he was being an honest lawyer was the best on that one. Have I been following the Young Thug stuff? Not recently, no. Thoughts on the Tina Peters sentence? Sucks to be her. Sucks to suck. 4.5 minutes of silence for you owe royalties to John Gage, only if it's precisely the right amount of time, but I did see enough to see that the new judge is less impressed with the case than the old judge was. Of course, that's actually pretty easy. Alright, so beyond that, we've got two things that we could cover today. I suspect we're only going to get to one of them. The one that I think we're going to get to is the WordPress stuff. The one that we might get to beyond that, there's an interesting copyright case involving the Broadway musical that everybody knows was made about rumors, and now the sound engineer who wrote a book that pretty definitely went into that musical is suing for copyright infringement. If we've got time, I'll cover that one. If we don't have time, we won't. All right. Other questions before I get rolling? Nope. Questions going once, questions going twice. Of course, you're like 30 seconds in my future, and I'm saying this, and you're like, hey, I haven't even finished typing yet. What's the Rumors musical? I don't remember what the hell the name of it is, but somebody basically has done, not even positive it's a musical, somebody's done a thing that's doing very well on Broadway, and it's basically the story of the Fleetwood Mac album Rumors. I mean, Playwright says it's not. Everybody who's watched at it is like, oh, give me a break, it's definitely that. How's the political race locally? I spent all day Monday, well, not all day Monday, but I spent a decent chunk of time on Tuesday working on, my campaign finance reports for my candidate. And that's that. Other than that, it's Hawaii, guys. There are relatively few competitive races out here. All right. Hey, lots of people with access to grind are watching this stream. Okay, well, grind away. Let's jump into the thing that I'm suspecting people want to grind their axes about. Wow. Boy, I really should have done camera 2 instead of camera 1. Who the hell cares? All right. You know what I can do? I can move my smiling face over just a little bit that way and move it back behind there. There we go. And move that back behind there. And hell. Nope, I didn't want it all the way back there. Alright, hell with it. Yeah, sorry guys, like I said, I redid, I got a new computer, and when you get a new computer, it takes a while to get everything set up just the way you had it before. There we go. Now you can see see everything. Hey, Megabyte Rose. Alright, so let's get started on this one. This is, as you might guess, the case that got filed yesterday in the Northern District of California. I did not look yet to see which judge they drew. WP Engine suing Automatic. We're in federal court because we've got Computer Fraud and Abuse Act, but we've also got claims for declaratory judgment under the Trademark Act. For the non-lawyers, one of the inside baseball things that lawyers need to figure out a lot of the time when they're launching a lawsuit is, what court do you want to sue in? For example, if you are suing the federal government and you want to have a law declared unconstitutional, right now the place to go is one of several one-judge courthouses in Texas that are federal courts. So you have to figure out how to jiggle your complaint to make sure that you can get your case there. For this kind of case, the big, in my view anyway, these, without having read it in detail, those are the claims based on the fact pattern we talked about last week that I think probably have the most legs. Most likely. They might not have, it's hard to say for sure. They might or might not have, not the extortion one. No, I don't think the attempted extortion's got the most legs, but these other ones are the ones I think have, that one less so. The contractual interference claims, and that covers both existing and prospective contracts, and promissory estoppel, strike me as the ones that are most likely to be the strongest. These kind of come in second. I'm expecting these to mostly be performative. That one is borderline frivolous, in my view anyway. Which leaves those two in the middle. I don't know about the competition under California as much. I'm not a California competition lawyer. Now, one thing that I will say Quinn Emanuel is good at here. All right, so I need to, I've got people in the chat who aren't usually in the chat. How many lawyers do I got? How many people work for tech companies but aren't lawyers? how where do you want the explanations calibrated today? High, medium, low? And how much inside lawyer baseball do y'all want? Because, all right, a lot of tech not lawyer I'm seeing, especially from the newer folks. High end of medium low. Thanks, Biscuit. Real helpful there. Break it down. All right. If you're going to be involved, first of all, if you're considering becoming involved in a lawsuit as a plaintiff or defendant, rethink some life choices if you can. Time being a linear function, you may not be able to rethink those life choices in time. But in general, if you are considering suing or being sued, it's probably something you all want to avoid to the extent you can. Getting sued is unpleasant. Suing is usually less unpleasant than getting sued, but it's still unpleasant. When it comes to lawsuits, I have a good time when I participate in lawsuits. I'm a crazy man who is a lawyer. I participate as a lawyer. But that said, if you are going to get involved in a lawsuit, and particularly if you are going to get involved in commercial litigation, meaning lawsuits on behalf of the company that you own, the company you work for, and that kind of thing, you need, in this day and age, to recognize, especially if you work in tech, that legal filings are going to be discussed on streams. They're going to be discussed in Discords. They're going to be discussed in Slacks. They're going to be discussed on Twitter. Court Listener, which is a wonderful thing, and one of I contribute money when I can to the Free Law, which is the group that runs Court Listener. The filings are easy to find. They're a little bit less easy if you're in state court than federal court, but even then, people care enough. Somebody on somebody's Discord is gonna run down to the courthouse and make copies if they have to at 25 cents a page. You know how I know? I've done that for a forum back in the Obama birther era, when we were mildly entertaining ourselves by watching the lunatic litigation stylings of one Orly Tates. I would run down to First Circuit in Honolulu, pay $0.25 a page, and make copies. Scan them. They go online. Because of that, your first audience for your legal filings is still the court, but you gotta write them with the public in mind. Meaning you have to be able to write well for two audiences simultaneously, which is not an easy thing to do. This is a great first line for a case. Hang on, let's go back to yellow. There we go. That's a great first line for a case. It's the theory of the case. Lawyers always have a theory of the case. A lot of the time, you don't say it out loud. Your theory of the case might be, they are a thieving asshole who thieved from our client, and that's why I'm in court. That's the thing. It's the story you want to tell, the core of that story. This is a good way to start telling the core of the story. Abuse of power, extortion, and greed in an open source community that's built on freedom to run, build, change, and redistribute. Well done. Um, Now, at what Quinn Emanuel is undoubtedly charging, you would hope that they would do it well, but you'd actually be surprised how much a big law is still kind of bad at this. What is WordPress? They could have taken this down a little bit because you never know if you're going to draw a senior judge who was, appointed to the bench by Ronnie Reagan. But filing in the Northern District of California, you can generally assume a reasonable amount of tech savvy on the part of the judges. So, not defining that right off the start, probably good. And more to the point, the punchline is there. Allows people to publish and create their own websites. Early success. The source code and trademarks were initially owned by Automatic. In 2010, in response to mounting public concern, the source code and trademarks were placed into the nonprofit WordPress Foundation with them making sweeping promises, that goes to promissory estoppel, of open access for all. This means the most central piece of WordPress's identity, its name, is now fully independent from any company. Except, that's not what they're saying today. I know this is a little bit of a jump. But their associate general counsel today is saying that there are actually two owners of the WordPress trademarks. One of it is them. They own everything that goes to commercial uses. All of it. And that they're staking a claim that users have the right to refer to genuine WordPress software by name, with genuine software coming only from a WordPress Foundation or Automatic approved repository. For those of you who are in the WordPress community, is this anything you've heard of before today? Is this a thing that anybody has heard of before today? This is a fairly sweeping claim because this is the claim that says basically that Automatic has the right and WordPress Foundation have the right to determine what is and what isn't authentic WordPress, and they have the right to come after you, yes, you, if you are using WordPress to refer to something that is not genuine WordPress software. That's a fairly broad claim. Now, ordinarily, that is a thing that, sure, you can do that as a trademark owner. The problem is also, does any, it's not even, it's an explicit mirrors aren't legit. Mozilla does something similar with the Firefox trademarks. Yeah, and Mozilla can, because Mozilla has very consistently exercised control. Mozilla has extremely consistently expressed control. My understanding is WordPress, until now, kind of hasn't. The right to nominative fair use doesn't include logos, and it doesn't include the right to use WordPress marks in a manner that suggests one is offering a product or service that comes from WordPress or is officially affiliated with WordPress. For example, calling a service WordPress hosting would not be nominative fair use. This is also a position that I understand they've never staked out before today. For those of you who are in the WordPress community, you need to be watching this case very carefully. For those of you who are WordPress devs, commercially, who work with this on a regular basis, if your companies are involved in this space, if you're in a position to talk to legal and suggest that legal keep an eye on this if they're not already, it's time to talk to legal and make sure that your legal, if you've got in-house, of course, is tracking. Because, yeah, this is what legal is for, guys. I know. I mean, a lot of what I do is outside counsel. Some of it is outside counsel to tech companies. But legal probably wants to be watching this carefully if your company is offering any services that use WordPress. If you're using WordPress in any of your marketing or anything like that, probably a good idea to make sure legal is tracking. And yeah, blank hosting seems pretty common in tech, and also I took a look at... every time I think about resuscitating my blog, I think about going to WordPress, and then I decide it's too much trouble and don't bother. But every single time I start doing the Google searches for that kind of thing, I am bombarded with 98,000 WordPress hosting services, all clamoring for my attention on Google. I mean, put it another way, even I know that calling a service WordPress hosting is incredibly common and has been since, oh my god, when did I stop blogging? Wow, it's been that long. Alright, we're just going to leave it there. When I was doing blogging, I was a scientist and not a lawyer. Alright, and what about the rights of software developers and copiers? The software is released via GPL, but it's not a trademark license. So the right to use, modify, look at, and share open source software does not give you the right to use the names. They are... really going to try to claw back the trademark, I think. They're going to try hard, and if the folks who are saying that there have been rumors that this ain't the first time Matt's taken a swing at getting automatic some licensing fees on this, yeah. And Robert, to be technically correct, I was a PhD candidate in zoology, not biology. Why zoology instead of biology? Because I am a really sucky botanist. But anyway, this is honestly, out of everything that I've seen, thanks Crazy IT Guy, out of everything that I have seen out of WordPress Foundation and Automatic, this is the one that would worry me the most if I worked in the space or I was representing somebody who works in the space. That's the one that would concern me the most. The other stuff has primarily been restricted to WP Engine. And the WP Engine stuff, your big concern there is making sure you're not next. This is a much larger concern because Automatic is gearing up, it looks like, to more actively assert control over the marks. Can they? I don't know. On the one hand, I genuinely don't know. And finding out would not be cheap. By the way, My my prediction, or my rough sense, is that both, unless this thing settles early, both Automatic and WordPress engine, WP engine, sorry, are into. They're heading rapidly for seven-figure legal spend on this battle. Very rapidly heading for seven-figure legal spend. Yeah, easily seven-figure. I work for a boutique. I work for an inexpensive boutique. And we've put together litigation budgets for seven-figure litigation at our rates for stuff that is not spectacularly more complex. But yeah, Neil Kachel bills, he's got to be billing high side of 1,500 an hour, and he is probably billing high side of 2,000. I bill, in other words, under a quarter of what Kachel bills. Possibly under a fifth. 2,400 an hour, then yeah, I bill under a fifth, or thereabouts. Actually, I might be billing about a sixth, but yeah. Is he worth it, or are you just paying for the name? He would not be my first choice for this case. And you can be undefeated against another firm as much as you want, or as long as you want, but that kind of brag strikes me as bloody stupid. Yeah, no, I mean, this is seven-figure going into summary judgment. The combined legal spend may hit 8. But yeah, you want the best specialist in the area you can afford. But my thing is, this ain't Kachel's area. He's a person I would go to if I have an appeal. He's a person I would go to for a Supreme Court thing, except that all lawyers are mercenaries, but there are lots of different mercenaries, and like Wagner Group through, a rent-a-cop. He's not at the rent-a-cop end. Yeah, the Quinn lawyer is an IP lawyer. He's an appellate lawyer. Now, he is certainly gonna, he's certainly going to be farming it out to other people in his firm. I doubt he's going to touch the file very much. But he's really pricey, and he's not well suited for lead for this case. This is an IP case. You want an IP lawyer. I mean, I don't know how much clearer to make that. Is it because he's anticipating a Supreme Court decision? You would have to be stupid to anticipate a Supreme Court decision on this case. Sorry, that came out wrong. Because I meant if you're a lawyer, you would have to be stupid to be thinking that this is likely to go to a Supreme Court thing. Obviously, it's an obvious question for a non-lawyer. I'm sorry. But one of the reasons I reacted as strongly as I did just now is because, yeah, it's who you would pick for somebody, if you were anticipating that, but you would have to be a fool to be anticipating that. It's not the kind of... It's unlikely to be the kind of case that has the issues of law that would appeal to the U.S. Supreme Court. Yeah, I think he's going to be more the name, but who the hell knows? And yeah, you don't need an appellate lawyer to try cases at the district court. I've watched my boss go up against an extremely good big law appellate lawyer. In an arbitration hearing. Some people are better suited to trial. Some people are better suited to appeals. All right. Anyway, moving on. What defendants' statements and assurances did not disclose is that while they were publicly touting the good deed of moving the IP away, they quietly transferred irrevocable exclusive royalty-free rights back to Automatic that same day. That meant from far from being independent of any company, control over WordPress's trademarks effectively never left Automatic's hands. That's a little, you know. Despite the promises defendants made to induce companies to build their businesses around WordPress, defendants are now misusing the trademarks for their own financial gain and detriment of the community. WPE, founded in 2010, is one of them. All right, last 2 weeks is a scheme. I'm jumping forward through the parties. Section 10, paragraph 10 is very long because they want to make sure that they've got personal jurisdiction over Matt in California. I think they made the case. Case or actual controversy for declaratory judgment. Fun fact. If your client, if you're a lawyer, all right, so for the lawyers, actually. Lawyers, lawyers in the chat, help me educate the non-lawyers in the chat. If you're a lawyer in the chat, and you've got a client who comes to you because some absolute complete muppet of a has sent a cease and desist letter to your client, what is something you need to think about doing? What is the thing you need to at least start to consider? Don't give me highs, Rochelle, please. Yeah. Declaratory judgment, approximately. Declaratory judgment. What a declaratory judgment is you go to the court and you ask the court to declare you didn't do it. And the reason that you do it that way, potentially, is because you don't want to necessarily have the cease and desist letter hanging over your head indefinitely. So, yeah, the shaggy offense, I like that. I like that, Amateur Hour. Haven't heard that description before, but it's about right. You go to the court and you say, I didn't do it ahead of time. And in this case, that cease and desist letter that Automatic sent, and that way you get to pick the venue, and you get to frame the case. You get to be the one who puts the allegations in the complaint. Now, a lot of the time, it's not worth it. A lot of the time, it's not a good idea. But if you've got a client who comes to you with a cease and desist letter, it's a thing you got to consider. Is this, do I advise the client to stand tight? Do I advise the client to sue? Now, there are requirements for a declaratory judgment. In part, it's got to be pretty clear that there's an actual live dispute. But Automatic cease and desist letter so clearly framed this as a dispute heading for litigation that there is no doubt in my mind that there is standing for a declaratory judgment action here. All right, so general allegations. We're WordPress engine and we're cool. We're nice. We're helpful. you guys, hit exclamation point popcorn. You can get the links to it, and you can read the stuff I'm skipping. Don't worry. Because I'm always going to keep calling them WordPress engine, and that's not necessarily great for them or not necessarily bad for anybody, But anyway, because WPA's products and services are built to work with websites developed using WordPress open source software and open source WooCommerce plugins, they reference the challenge terms. Yes, they do. They do it the same way everybody else does. Yeah, gonna be an exhibit high future court, I know, right? The WooCommerce adds functionality for shop. They've consistently used the term WordPress since 2010. They've used WordCommerce since 2018. And I'm going to go out on a limb and suggest this. They can absolutely show that Matt and Automatic knew they was doing it. By the way, that's important because, first of all, there is, statute of limitations. But there is also, for those of you who started watching my stream at the very start when we were doing 2020 election stuff, there's this thing called latches. Now, when we talk about latches, we're not talking about the thing that I had a key to as a Gen Xer. When we talk about latches, that's LACH, no T in law. Latches is you slept on your rights for so long that it is unjust for you to sue us now. Unclean hands is a lot. Me. Now, unclean hands is a lot, and then I look at the chat and I'm like, Matt was investing in them while they were doing that, and I'm like, okay, maybe unclean hands is not a lot harder. Unclean hands goes toward, basically, if you're going to ask a court to do equity. Now, I don't know that we've actually got any equitable remedies, so unclean hands might not apply as a defense, but if you're going to go to the court and ask for equity, you have to come to the court having been equitable. Investing in them, not bitching about what they were doing, selling the investment, and then bitching about them, that's not equitable, and that's not equitable within the scope of the same debate. Or same dispute. That's unclean hands. Alright. Faster... yeah, they were using it in 2010. This is, by the way, a very well done complaint by Quinn Emanuel. And I don't say that... I'm predisposed to not love Quinn Emanuel right now. They're opposing counsel to me in a case. But this is a very well done complaint. This is good use of... Oh my god, did they actually... Yeah, their support staff is awesome. Look at that, although, I mean, look at that. They lined they got the header for they got the header for the screenshot lined up with the pleading paper. Lawyers, tell the non-lawyers just how actually noteworthy getting the lines to line up with the pleading paper on a page that is nothing but screenshots is. Alright, so they've consistently been using it, and it's really well done showing that they've consistently done that. Formatting matters. Formatting matters. Of course, then they lose it here, but hey, still. Nobody actually expects the actual lines to line up. It's when you get that to line up that it becomes a little bit more. 5 for future, but yeah, so basically Mullenweg, Maddie, and Automatic knew. Um, Vote with your wallet. So when you support companies like WPE who don't just provide a commercial service but are part of a wider open source community, you're saying, hey, I want more. And on the day he did that, their website said, we give you a smarter way to WordPress. The line numbers are, how do I do the line numbers on there? I say, Catherine, help! That's how I do the line numbers. During a live stream on September 26th on the X platform, when he asked why he had not attempted to enforce Automatic's trade. Oh, they were listening, were they? Oh dear. Is this the consequences of your big mouth coming? Does latches apply if Newfold holds a current commercial sublicense? Who's Newfold in this context, guys? Sorry. During a live stream on September 26th, when asked why he did not attempt to enforce, he admitted he'd known about the use of the challenge term for years, but opted not to take action. Newfolk is the one company they said they've actually successfully gotten money from. Aha. So what I'm suggesting is that what that suggests to me is that Newfold actually may have caved. In 2003, going back to WordPress platform. After WordPress was publicly recognized as a 501c3, caused them to transfer ownership of the marks and publicly announced that transfer. He did that around the same time of public concern over his level of control and potential for abuse. The public announcement did not mention that he granted an exclusive, fully paid, royalty-free, perpetual, irrevocable, worldwide subsidy. Oh. Oh, baby. Yeah, that's just keeping it under your control. Oh, baby, man. Failed to disclose the exclusive licensing arrangement between his nonprofit and his for-profit in the WordPress Foundation's tax filings with the California government, claiming there were no contracts between WordPress Foundation and any officer, director, or trustee, or with an entity in which any such officer, director, or trustee had any financial interest. This statement was false, given that Mullenweg was a director of WordPress Foundation while also having a financial interest in Automatic, the entity with which the foundation had entered into the license agreement, an apparent self-dealing transaction. Also did not disclose the license agreement in the WordPress Foundation's filings with the IRS, and none of their 14 years of publicly available financial reporting indicate that the WordPress Foundation was compensated in any form. Well, we now know that what they're claiming is that the reason they weren't... So what they seem to be positioning themselves to claim now is that the reason that there wasn't any payment for that was because... really, they didn't actually technically give the WordPress Foundation the trademarks. They effectively sold the WordPress Foundation the trademarks. That seems to be their claim now. So, while the foundation has failed to ever disclose to the IRS its ownership of the trademarks or the existence of the royalty-free license, for the past 7 years, Mulwig himself executed the IRS forms on behalf of the foundation under penalties of perjury. Yeah. Their argument is, to be clear, I saw a question pop by, is that the foundation got all the non-commercial rights in exchange for giving back the commercial ones. Which is effectively not really different from a sale. For the 2010 year, when the apparent self-dealing transaction was executed, the foundation chose to file the 990E postcard, requiring no certification, no financial detail, except a certification that they've got gross receipts of under $50,000. For the subsequent year, they filed a more 990Z that said they only had 14,000. No trademarks or other valuable IP were reported. When the hell did they register these marks? In a number of public statements about the WordPress trademark, Mullenweg also failed to disclose the critical fact. That's in the exhibits. Yeah, I know. I don't really want to look it up yet. But, Mullenweg also failed to disclose the critical fact that for a for-profit entity he controlled held the exclusive WordPress trademark rights. To the contrary, the comments appeared intent on providing false assurances. That's another key phrase for promissory estoppel. That the WordPress trademark rights were safely in the hands of the nonprofit foundation. In 2010, Mullenweg stated, "It's not often you see a for-profit company donate one of its..." Oh, that is so specific. Oh, beautiful. Beautiful. There is something that holds the WordPress code and trademark for the free access for the world. Sort of. Asterisk. This statement does not include the valuable commercial trademark rights. And also, doesn't WordPress operate under GNU? I know. But I've been saying GNU since I failed out of a computer science degree in 1990. I'm not going to go how early in the 90s I failed out of the computer science degree. Isn't WordPress under GNU because, in part, they used a whole lot of building blocks that came out of GPL anyway? I mean, isn't that like part of the reason that WordPress was using that was because, yeah, it was forked from another project that was GPL, and they kind of had to, or at least some of it. The open source software is hosted by and through WordPress.org. Also has plugins, themes, and other add-ons created by software developers in the WordPress community who wish to share their work with the rest of the WordPress community, and hosts other services. Despite its .org top-level domain, which is commonly understood to be used for nonprofit entities, so much so, in fact, that when you see tech lawyers, and I think there have been a few who have been doing it, when you see tech lawyers who've been saying, talking about WordPress.org owning the trademarks, it's because it's very natural in a situation like this to use the .org as the synonym for the foundation. When you say the .org, you are talking, at least in theory, about the nonprofit. In the following message you posted on Slack on September 22nd, thank you for your opinion there, but I do ultimately control WordPress.org, and I think this post is appropriate to go into every dashboard of every WP install because what WP Engine is doing is so harmful. I keep forgetting that he pushed the message through the admin panel, right? He commercially attacked them through the admin panel on the .org website. Yeah. That was just bad. That was just dumb. So yeah, apparently, well, the thing there is that I don't even know if because Matt controls the foundation also, I don't know if he's talking about the foundation or the website, actually. Now, this one's, on the other hand, is much less clear. Much less vague, I mean. Just him. Similar statements on a message posted on Slack to the effect that it belongs to them, it's not part of the foundation or any trust. I run it in an open way that allows lots of folks to participate, but they don't own it. This guy's got some control issues. What corporate veil? What veil? In an interview, he said he's been running WordPress.org for 21 years. Defendant's promises. The core software is open. On WordPress.org claims that the WordPress community is united by spirit of open source. Everyone is welcome. Provides the opportunity for anyone to create and share. Commitment to open source, which is freedom to run, freedom to change, freedom to redistribute, and freedom to distribute copies of mods. Explain that they're committed to being inclusive and as accessible as possible. We want users to be able to publish content and maintain. Made even more specific promises to third-party software developers. It's architected in a way that lets you create plugins and themes. Strongly encourage them to share by uploading them to the repository. Operate an authentication system which controls access, including the ability to submit plugins and themes. Hosts an entirely separate developer website to encourage third-party software developers to build plugins. Nowhere on the website does it say that the developer must pay money to WordPress to host their plugins or that access can be blocked at Mullenweg's whim. Fair. Developer access creates facts which say if a plugin submitted will be queued, as soon as we get to it, we will manually download and review your code. If we find no issues with security documentation or presentation, plugin will be approved. Also contains language that describes the conditions under which plugins are not accepted. Defendants have openness in the trademark. Foundation is represented to the IRS that the foundation will be responsible for protecting WordPress, WordCamp, and related trademarks. Has stated that it was free access. Consistent with nominative fair use, nearly all third-party developers prominently display WordPress. Yes, I mean, I could confirm that very, very quickly. Coercive threats, we covered that last week, guys. Catch the VOD if you want more. I'm not gonna... Again, we've got good use of screenshots, but this is very redundant of what we've looked at last week, so I'm not gonna double check. I mean, look, we're at page 25 out of 98. They carry out their threats. We covered that last week. False and disparaging statements. All right, so for the non-lawyers and for the people who are new to the case, I am at the outset. The text to Heather was new and interesting. What page was that on? All right, where did I miss new? Because that's later. Okay, yeah, I was gonna say because we saw this. We definitely saw that. That we saw last time because I chewed on a knuckle. Carry out the threats, turned into a multi-front ongoing attack. Reflect a clear abuse of his continuing roles as a director with ownership and control and CEO of two competing nonprofits. Yeah. Here's a... Yeah, I saw Automatic's response. There was nothing in there. It was a, yeah, we're going to deal with it when we deal with it response. There was nothing interesting in it. One of the so here's another concept for you non-lawyers: standing to sue. One of the problems with everything that's going on here is that it's actually hard for there's huge problems with the relationship between the WordPress Foundation and the control of the for-profit website and the rest of that. But the issue with this is that it's hard. WP Engine doesn't have they don't have what am I looking? What's their injury, basically? Their injuries are coming from the things that Matt's done directly to them, but they don't really have the ability to bitch and moan too much in court about all of the breaching of the corporate veils and the commingling and all the rest of that stuff. So... yeah, and yeah, to reiterate reiterate TLDR on the change of counsel, they were better off with Perkins, and I don't actually rate Perkins that highly for tech law, but they were better off with Perkins. Ketchel might be the right lawyer for this case in 3 years, but I don't think he's the right lawyer for this case today. Anyway, false and disparaging statements. During the keynote, made false and disparaging statements, just wants to feed off without giving anything back, suggesting that their employees might be fired. Customers should watch his speech and then not renew contracts when the contracts are up for renewal. Claiming that if the customers switch to a different host, they might get faster performance. Alleging that they were misusing the trademark by including the initials in its name. The investor doesn't give a dang about open source ideals. Those are not demonstrably false statements, guys. Those are opinions. Those are opinions. They're not demonstrably false statements. Takes a lot of time and energy to create and support themes and plugins, keeping them updated. Every contribution counts no matter what it looks like. They've contributed tens of millions in ongoing support through event sponsorships and educational resources. Yeah, this is the claim that they're misusing the trademark is false. There's false and then there's wrong. Um, for example, now they're now using the trademark thing, and I think that's bad. But yeah, false and unsubstantiated. I don't think most of that's actionable, really. Um, what's the difference between false and wrong when it comes to that, the trademark usage? Wrong is an opinion that you can honestly have in the way that I'm using it. False is you're a lying asshole. Wrong is you're making an argument that just isn't correct. They are different legally. There are important differences between being a knowingly lying asshole and just getting it wrong. And when you're talking about claims that the phrase lawyers use is sound in defamation, that means that they might not be defamation claims per se, but they're claims that are close enough for jazz to close enough to for jazz to defamation, which includes trade disparagement, slander and libel or subcomponent, all of that stuff. The thing about all of that is that if you're a public figure, and in a lot of states, public figures if you're a public figure, so when an opinion become slander or libel? If you can prove that he doesn't honestly own the opinion, only really, in my view anyway, most likely, unless the California law is the law that would apply here, and unless their trade disparagement law is more generous than most states, usually for the trade disparagement, you've got to show the equivalent of what's called actual malice in the defamation context. And usually that is, you have to show that they knew what they were saying was false. Not just they were, that they lied and they knew they were doing it. So in order to make an opinion actionable in this context, you have to, contrary to popular belief, you can actually defame someone with an opinion. It's just that it's incredibly hard to do it because the opinion has to be factually correct in that they have to be lying about having that opinion. Not just lying about... So the opinion... You can actually, in some cases and in some circumstances, get to a defamation thing based on an opinion if you can show that the fact that they hold the opinion is going to get other people to also hold the opinion, and they're lying about having that opinion. But it's virtually impossible to prove that. So yeah. The closest, and I think, yeah, this is the bit where, see, what I would refer to that as in the Hot Pocket, not just yes, but oh fuck hell yes. Going back to what I just highlighted here. This would be an opinion that is stated on expressly disclosed facts. It's just that it's a stupid opinion. It is a dumb opinion stated on disclosed facts. It is dumb to say that something is chopped up, hacked, and butchered, but it's a cheap knockoff just because they're disabling revisions by default. However, if you do that, if that's honestly your opinion, and you've stated why you held it, then you have given the thing, and everybody who looks at it and knows what they're saying can say, this is a stupid opinion, and discard it on their own. Now, I would say that if I had to go to the wall on that, I'd be willing to cite that as evidence that he didn't honestly hold that opinion. I would, but in order to do that, I would also have to prove that Matt Mullenweg is not, in fact, stupid. Let's see. In another post, it's free to offer their hacked up, bastardized simulacra of the GPL code to the customers. Okay, that one is actually plausibly there. That one's plausibly there. That's enough to make me say that claims sounding in defamation are not going to be frivolous. I think there's still going to be a hell of an uphill push, but not frivolous. False, misleading, and disparaging statements. All right. Blocking access to WordPress.org. Block them from updating WordPress plugins that it publishes through WordPress.org. That's an issue there. Block them from accessing a host of functionality typically available, including the ability to submit and edit code contributions. How about if Matt already started to apologize on X? Is he doing it now? Is he apologizing now? Because, I mean, he's crazy enough to start trying to walk it back. Oh, God, I don't really want to look, do I? But of course I'm going to look. Oh, that's him being sarcastic. Yeah. He's done... So there are clients that you muzzle. Then there are clients where you take the client's electronic devices to a road construction site. You look for, and there are gonna be enough geeks here that I'm screwed. You look for the steamroller, which I know is not a steamroller anymore, but you look for the big, horking, heavy wheel thing, and you put the electronic devices under that while it's moving. You do that. There are some clients where that is what you do. And then there are clients where you think seriously about whether or not you should take their pants off, first, or just throw the whole lot under the roller. Different levels for different circumstances. And yeah, y'all, and somebody can clip it if you want to, for purposes of whatever. CC, yeah, do this one as CC BY, because I don't want people to argue about whether or not clips are derivatives or not. CC BY is fine. And in my view, as a guy who does copyright law, that's enough to make that offer firm. And yes, CC BY for both is fine. Anyway, meant that WPE identified that one of the many plugins it created are in use, but it would no longer be able to publish the update. That's bad. Oh my God, he's no, not Y Combinator. All right, same time withdrew login credentials for individual employees, preventing them from logging into their personal accounts including the community Slack channels. Oh dear. Oh. Then wrote a blog post saying that WP Engine is banned, no longer has free access to WordPress.org's resources, many of which WP Engine, correct me if I'm wrong, but didn't WP Engine contribute many of those resources? Further escalation, I can't even pronounce stuff today, prevented WPE customers who host installations from access. Oh. Oh my. He may no longer be able to offer free access to the forums or Slack due to discovery. What fundamental differences do I see between this and Carbolic Smokeball? Great question, and I need to take something down and show it off. Fortunately, I don't have access to A4 frames, so this is just blue tacked on. Well, blue tacked on, but it's just blue tacked on. For the lawyers. Carbolic Smokeball. I'll think about it. But I mean, if I had the frame, it would be, well, it might be easier to do that, actually. Yeah. Carbolic Smokeball is a famous contract law case. The Carbolic Smokeball Company put this ad on page 119 of the Illustrated London News in the 1890s, saying that they had put money aside, £1,000 deposited, to give out £100 rewards if, to do, oh, I'll have to check for that. £100 rewards if you used their product and got sick. The Carbolic Smokeball then got sued when they didn't give it out. And they said basically, it's just an ad. It's not a contract. It's just an ad. And the court said basically, lol, no, that was a very definite offer that was open to the public. I would have to think about whether or not I would go that particular route, because that's a contract, in fact, if I remember correctly. Whereas it wasn't a contract in fact. This is more of a promissory estoppel, a pseudo thing. Yeah, the difference between basically the difference between Carbolic Smokeball and, in fact, my recollection, I would have to go over to that bookshelf over there where my contract law case book is still hanging around to check the Pepsi case. But the Pepsi Harrier case failed on the look. People had reason to believe that Carbolic Smoke was making a serious offer. Nobody in their right mind thought Pepsi was actually offering a Harrier, which is why the cases turned out differently. Reasonableness of the expectation. Even one guy sort of did, but he was like, wouldn't it be funny if? And the court was not nearly as amused as he was. All right, anyway. During a live stream interview on YouTube, publicly took credit for carrying out the retaliatory actions. Publicly stated he gave advance warning. That is false. He gave no notice at all. Discovered the misconduct when its engineers attempted to log into their admin panel as usual, only to discover their accounts were all disabled. That must have been a fun day at the office. In the same interview, was defiant and remorseful and said, "Please sue me." What are you going to do? Stab me, says stab victim. And yeah, on the discoverability thing, it doesn't make any sense because that's all discoverable. You can't take it down now. And if you take it down now, you've got to preserve everything in full. So the idea that you would need to take that stuff down because discovery, unless your plan is to broadcast to the world that you are going to, vocabulary word for the non-lawyers, spoliate. S-P-O-L-I-A-T-E. Deliberately get rid of the evidence. And yeah, carbolic smoke is, by the way, it's an English case that gets cited in the US, and in New Zealand, and in Australia, and in Canada. It's a pretty foundational one. But yes, and inferences. If you get caught spoliating, basically what happens is that the judge tells the jury, okay, look, just assume that was whatever was in there was really, really bad for them. And that's why they got rid of it. Alright. In other posts on X, seems to have justified in part because of Stripe issues. Happy to unblock you, drop your legal claims, and get a trademark license. They could fix their trademark and Stripe issues? That makes no sense. Oh. Okay, I'm glad I'm not the only person who thinks that makes no sense. I mean, yeah, I know what, Stripe is, I'm very professionally familiar with Stripe. Stated that WP Engine earns tens of millions annually from using WP's Stripe connection. Yeah, I would think that they're less. But yeah, no, Stripe is the payment processor. So yeah, I mean, actually, here's what I'm going to ask, Megabyte Rose. Is there an explanation for what he says with the Stripe stuff that makes any sense? Because if there's an explanation that makes sense, then we should probably hear it. But if there's just a different chunk of ways where it's bizarre and everything, then maybe not. He claims they modified to redirect Stripe revenue from automatic. Okay. No comment. Yeah, that's kind of, yeah. He thought the affiliate money was a lot. All right. Tens of millions annually? No, it's barely tens of thousands annually. They actually created their own plugin. Seek to capitalize on the chaos they created. To try to directly capitalize, he used another company he owns, Pressable, to tell clients to breach their contracts and move to Pressable. That would be interfering with their contracts. Beginning with the keynote, urge their customers to reconsider renewing and push his own company. Well, I hope we can get every single customer to watch this presentation. And there's some really hungry other hosts. These things are Blue Cloud hosts, Pressable, etc. Oh, fuck. Oh, God. I don't think it hit as hard last week. Um, Now, again, the thing about tortuous interference with contract, it was on Blue Sky after, okay. The thing about tortuous interference with contract is that you do need an independent tort, not just interference, but that is interference. All right, look. The way law works is every claim. So, like, copyright infringement is a claim. It's not a claim in this suit. I'm just going to use it as an example. To win a copyright infringement claim, you need to show that you own a valid copyright, that the defendant copied material that was copied material that is covered by your valid copyrighted thing, that they did so without license or other permission, and that the material that they copied is protected by copyright. Because not everything in your copyright protected work may be protected. Facts that are in there might not be, etc. Each of those things is what we call an element of the copyright infringement claim. And what you have to do to win the claim is you have to go down the list like it's a checklist, because it's a checklist. And you have to check, like, did I prove ownership? Yes. Did I prove, if you've ever been on a jury, you've effectively been asked to do these checklists, to check off the elements of the offense, to check off the elements of the tort, the elements of the civil claim. One of the elements for tortuous interference is attempting to induce people to break their contract. Even with a separate CEO, I'm going to bet you, given how dumb Matt is, that they're going to be able to provide enough evidence that that's going to check one of the elements. It's not going to check all the elements, but it's going to check an element. WordPress.com homepage offers 1 year. Migrate your WP Engine site and get 1 year free of any plan. Use any other web host in the world. Amid public backlash, attempt damage control. Oh, good. Matt Mullenweg needs to... The WordPress community members, well, hi everybody. Announced that he was temporarily restoring access, but not permanently. And then he reblocked them again on October 1st. As they continue to criticize, went into damage control mode to attempt to characterize WP as the sole target of their imperious actions, except that, again, in my view, and I'm going to just pop again, this is very much not restricted to... There's nothing in there that restricts this to just WP. So, sole target, I would be... again, if I'm advising somebody who is in this industry who is not WPE, and again, I am not your lawyer, and if you are in this industry and you are listening to me, this is me telling you, I would say that you need to talk to your lawyer, and I would say, your lawyer hopefully is going to just watch this carefully and maybe have other advice. This is not legal advice, except to the extent that, talk to a lawyer is legal advice. Made various damning statements demonstrating anti-competitive animus, including by stating that every other web host in the world we have no beef with. gave an interview to. They could make all of this go away. You know, maybe more than 8% is what we would agree to now. Also conceded that nobody was paying 8% as a license fee. Oh, beautiful. The reason I'm laughing at this is because, all right, again, lawyers in the chat, you've been served with a declaratory judgment action. What do you do? I mean, after, motion to dismiss and everything else, but possibly. But what are you going to do in response to a declaratory judgment action seeking a declaration of non-infringement? As the lawyer, what you're going to do is you're going to draft counterclaims bringing the infringement claim so you can get the infringement damages because, okay, so since somebody said you didn't understand, let me stop and let's break this down. Some of the claims that WPE has brought against WordPress, or against, is the foundation in? Let's see, I'm on 35. No, just Automatic right now. But the claims that they've brought against Automatic are claims for what is called a declaratory judgment action. A declaratory judgment action is when you go to the court with a complaint that says, this company is threatening to sue me for this. In this case, they are threatening to sue me for trademark infringement. Judge, tell them that they are out of their ever-loving mind, is what they're asking for, basically. Which means that instead of being the plaintiff in the infringement case, you come in as the defendant in the declaratory judgment action. But if you are sued, one of the things that your lawyer can do is sue back, which is called a counterclaim. If you are served with a declaratory judgment action for infringement, seeking a declaration that, they didn't infringe, if you beat them, there's going to be a declaration that they infringed, effectively. So you might as well bring the infringement counterclaim so that you can hit them up and collect the damages if you win. Because if you're just the defendant, you don't have the avenue to get the damages yourself. If you file the counterclaim, you've got the avenue to get the damages. So almost undoubtedly at some point in this sequence, Automatic and Matt are going to be filing counterclaims. What Matt just did with that statement is drop the maximum damages he can collect if he wins, because reasonable damages here are almost certainly going to be mapped off on a reasonable license fee. And Copycat, I read the letter. He wanted 8% of gross, not 8% of net, 8% of gross. And in a low margin, low profit margin industry, 8% of gross is kind of a lot. The rights to audit will and everything else. But, this should be absolutely taken very seriously. Especially since, again, that's being paid to a competitor that doesn't own the license outright and is the beneficiary of a self-dealing license back. 8% of gross or the equivalent to that in developer time. I mean, you can say reasonable or unreasonable or all you want to on that one, copy, but I would be stunned if anybody would agree to that. Because in part, you got a whole lot of, everything, given that it's a demand for a license that I don't think they need either. I don't think they need it either. Um, I honestly, I'm not even convinced there's a great trademark anymore. Um, but I don't see anything that makes me think that they need a trademark license. And the benefits of that trademark license going to boost the bottom line of their competitor, that's an issue. Not a lot of businesses are going to willingly agree to that. Genericide via non-enforcement? I mean, everybody has used WordPress hosting for the last, losing the trademark is complicated. I'll get there at the end. How's that? All right. Anyway, earlier in 2024, defendants had stated Automatic was in discussions for 18 months. That was false. They proposed a hosting partner program that would have involved collaboration to advance WooCommerce. Referenced the inclusion of a trademark license, but made no accusations that it was violating, nor did they ask them to make changes or references. And Automatic unilaterally shut down those discussions without agreement and was reassessing it. This all comes off as anti-competitive behavior by a competitor with radical control. Levying personal attacks against the CEO, gave an interview during... Did they blink that? Yeah. Continued in private. First attempted to poach her to come to work for Automatic and falsely suggesting. If she did not threaten to tell the press and the investor that she had interviewed with them? Is this dude on drugs? Is he on literal drugs? Premise was false as the CEO had never interviewed with. All right. Did not respond to the threat. Represents that it might seek to acquire them for a discount. He might take them over, not just seek a licensing fee. His public attacks would continue. In a social media post, he boasted that as a result of his... Oh, no. WordPress acquires WP Engine. Oh, that's some rando's take. Okay. I don't think they're worth a fraction of that now. Customers are... bad. I think the chances of him having that tweet read back to him by a lawyer in deposition approached unity. There's a mention of, if not a negotiation, then scorched earth in the text thing. Yeah, but yeah. I mean, look, copycat for the record. I'm assuming there's more than one side here, but this is masterfully setting out the one side, and it's really hard for the other side to be more than damage control at this point. This is like Google held trainings in writing saying don't put in writing that we want to crush competitors. Yeah. I mean, I'm sure there's going to be another side to see, but this is, even when you're baited, this is, look. Would you like something generic that is sort of, it's as close as I'm willing to come to legal advice, because it's a general kind of guidance. Would you like the general kind of guidance that's as close as I would be willing to? And this is a little bit of cliche. It's a thing that lawyers are known to say. It comes close to being, in fact, so for the non-lawyers, there are two kinds of lawyer joke in the world, right? There are the jokes that civilians tell about lawyers, and then there are the lawyer jokes that lawyers tell about lawyers. This is pretty close to the second kind there, all right? Dance as if nobody is watching, and write every email as if a judge is going to read it. And, I mean, there are times where I will be writing an email to opposing counsel going, this is probably going to be an exhibit in the next filing. If it's not mine, it's their exhibit, but it's probably going to be an exhibit. But in general, if you are in business and you are trying to crush your competitor, write every email as if it is going to come up in discovery. All right, this has hurt the customers. I'm going to take that as a given. Not to renew. Lots of damages evidence here. Can't access WordPress or update plugins. We're limited in what we can do for our clients. If we have an outage, we're screwed. If we can't get a solid answer or plan, we will have to consider moving our business and sites away. What are you being told? What is the plan? Yeah, that's a reasonable question from customers. Plugin updates or daily vulnerabilities, yeah. Frustrations about having to manually update sites, lots of damages evidence. The entire community is harmed, yeah, I think there's a very valid case there. It's destroying trust, if nothing else. The attempt to seize control back over the trademarks, in my personal view, is repugnant to basic free and open source principles. Once you've given it away, you gave it away. Does anyone know how long it takes to put a document like this together for a big firm? This is a 6-figure complaint at big law rates. This is a mid-5 at my rates. Yeah, the question isn't so much, though, how many, it's how many hours, not how many days. Because, and this is another, there are times when throwing lots of people at the problem doesn't work. For example, I need a baby in a month, somebody get me 9 women. That's not really a plan. But a complaint like this, you can throw at people. You can throw a lot of hours in. Um, yeah, over the course of 2 days, 3 days, this may have legitimately run up 100 billable hours. Um, there are lots of different ways to do social media monitoring. For those who aren't familiar, my law firm, we do a lot of work, our litigation team, in the anti cheat space. So there are a lot of different methods for monitoring stuff. Um, there are definitely, definitely. Um, but man, this is a $250,000 complaint. It is one of the better complaints I've read. They did not, however, have the best paralegal. They might have had their very best paralegal assemble it. They didn't have, most they could have come up with is the fourth best. Um, but yeah, there's companies out there that do it. There's services that are available. There are in-house tools that are available. I mean, I can think of at least 3 or 4 companies off the top of my head. In fact, I can think of 3 companies off the top of my head that we've either worked with or talked to and hope to work with that do monitoring for this kind of thing. You Yes, but you also want to be capturing it into so you have it available for depositions later. Um, but yeah, so I mean, which companies you use really depends on what you need them for. But there's a whole range of options out there. Um, I mean, in the video game space, in Torca, um, in the investigatory space, few different ones. My thoughts on the attorney who filed this complaint. Everybody who worked on this complaint is a rock star, at least so far. I don't say that lightly. And again, I dislike Quinn Emanuel on spec, or at least I dislike at least I. For those who Google what our firm does and what we're involved in right now, you can figure out which celebrity Quinn Emanuel lawyer I may not be a fan of. And that may be affecting my overall views of the firm because this is quality work. So yeah, no, the T on Quinn basically is that Alex Spiro works there. I mean, that's probably shading my views a little bit because this is absolutely outstanding top tier work so far. I mean, it's page 43. They've still got space to screw it up. For those who don't know, again, this is very public information. Our law firm represents a number of former Twitter employees in severance-related cases. A lot of high-level clients on copyright issues. I mean, she is good. This is a good damn complaint. The symbiotic relationship only works with openness and freedom. Yeah, he's destroying the community. Pending their legal claim. Oh, yeah. Yeah. Yeah, they did do that. Um, all right, now we're into the claims for relief. So, intentional interference with contractual relations. This is where you're stating the elements out. Um, and yes, please listen to Callie, who is the mod and is correct. Because we have new folks here, I'm giving background, but um, I don't discuss my cases. Not beyond identifying them anyway. And even that I only do rarely, and only if it's made press. Enough press for people to tell. Are there I can't tell yet, Hot Pocket. This is a case that's worth watching very carefully. In terms of strength, you notice this is very short. Do not mistake very short for very weak. This is very short because the facts that are stated there absolutely support the fact that they intentionally interfered, absolutely support the fact that they knew of the contracts, that they intended to disrupt performance, that it will prevent performance or make performance more expensive or difficult, and has been or will be harmed. Now, it may be, I don't see them stating an independent tort. That is sometimes implied. I would have to look at the California elements. But I think this is concisely and well pled. This is also prospective economic means you're keeping people from signing new contracts. Both of these claims, yeah. From Westlaw, so yeah, resulting damage. So that's checking off the California elements. Now, it may be that the acts can't be privileged in California, and I'm sure there's going to be some dive into there. But it's adequately stated, yeah. The elements are going to be very similar for this. Don't know, and again, this is going to be one of the stronger claims. So there's the difference. So for California, you don't necessarily need independent wrongful conduct for existing, but you do need wrongful conduct for prospective. And the reason I'm willing to make that is because I now have enough respect for the attorney who drafted this complaint to say that if they pled the wrongful conduct for that claim and they didn't plead it up for that claim, it's an element for this one and not for that one. These are state law claims, which is why I don't know what all the elements are off the top of my head. The fact that we still there's really not a lot of reason that we still license lawyers state by state on a formal basis. I mean, most states don't even really test state specific that much anymore. You test, the bar is almost a national exam at this point, but each state does have different common law for common law torts like tortious interference. The elements may vary some from state to state, and you have to look up the ones for each state to be able to know if you're going to do it right, or talk to a practitioner in that state, of course. This claim I'm not a fan of. Laughing in Louisiana is fair, although we've got a few cases left that we cite that are still valid, that are still good common law cases out here. So Napoleonic Code, you can laugh all you want to, but theoretically, I can cite cases as valid common law from the 19th century that were decided by the Supreme Court of the Kingdom of Hawaii. So our common law is a little different out here. We're not civil law, but we've got some little tweaks and quirks in our common law. because our common law goes State of Hawaii, Territory of Hawaii, Republic of Hawaii, Kingdom of Hawaii. Same Supreme Court, same court building. Same reporter volume, same reporter series. All right, the CFAA claim I'm not a fan of. I don't see a path to victory on there. I would almost call this borderline I don't know what all right, let me look at what A7 is. A7. Holy fuck, maybe it's not frivolous. I don't think they make it, but I can see the argument now. CFA might be able to get them to a preliminary injunction, but I wouldn't bet the farm necessarily. Yeah, I don't know. Threat to cause damage, I don't know. I'm still very skeptical, but I think I can see a good faith basis for bringing the claim. And yeah, you got to make the claim to argue the claim. Why would a preliminary injunction not be available on the other claims? I'll get there at the end. But yeah, and I mean, the key thing there is that they brought it in for entitled to a temporary restraining order, preliminary and permanent injunction. I'll do that actually right now. So in order to get an injunction is an order from the court that says stop doing dumb thing, or do thing because it would be dumb to not do thing. So yeah, they didn't hack into the system, but the damage to the hosting system by impairing the integrity and availability of data, programs, systems, and information therein. I think that's weak. I'm sorry, I didn't click back over. I think this is weak, but I don't think it's a non-starter. In other words, I can't think of a 1030 case off the top of my head that expressly forecloses that as an option. So they're not claiming it on the admin dashboard stuff. They're claiming it from the wrongful lockout. So I'm still not a fan, but one of the reasons they want this is this. If they want to get a preliminary injunction, which would be the way to force Matt to let them back in, to get the court order forcing Matt to let them back in before the case is completely done, they have to show what's called irreparable harm. Meaning that they have to show that if the court doesn't take action now before resolving the matter entirely, it may be too late at the end because the harm will already be done. So on this one, you bring it, the issue is that almost all the rest of their claims, their damages are money damages. And by definition, if your damage is reparable by paying money, it's not irreparable harm. Money is fungible. Cash, As long as it is a pool of the correct amount of cash, it doesn't matter which cash it is. It just matters how many bills there are. And the tortious interference, those are economic claims that are reparable with cash damages. Attempted extortion is reparable with cash damages. The claims that sound in defamation are not reparable, but courts are not going to First Amendment issues there with injunctions. So, yeah, the angle there is where the lockout prevents them from applying security fixes, which is damaging. So, no, I think that is exactly the theory. Yeah. By the time this case is resolved, we'll no longer have a functioning company. We'll get you there in some states, but it doesn't really get you there federally. But I'm skeptical. I could make this in-house. The phrase we use is when we're talking about, well, can we bring this claim, this kind of that claim. The test is kind of, can I write this down and sign my name with a clear conscience, clean heart and a clear conscience? And I think I could make that claim with a clean conscience. Attempted extortion, yeah. Unfair competition, this feels like unfair competition. And a lot of these, this is probably California's Little Sherman. The Big Sherman Act is the federal Sherman Act. States have Little Shermans that tend to go beyond the Big Sherman. They actually tend to be bigger than, the Little Shermans tend to be bigger than the Big Sherman. But this is, state laws prohibit unfair, unlawful, or fraudulent business practices, and oh my God, this seems to fit the bill. This absolutely seems to fit the bill. So if they can get injunctive relief under that also, then that's good. You want the federal one also, though. And blatantly motivated by anti-competitive animus I mean, they are very much trying to use a monopoly power over that platform that they have not used in that manner. Promissory estoppel is basically we made unambiguous promises about the trademark that we are now breaking. Promissory estoppel is tough. So, for the non-lawyers, promissory estoppel is it's a patch that the common law has created for when things feel like there should be a contract, but there wasn't actually a contract. That's actually more remarkable than it seems because you can have verbal contracts. It's actually fairly easy. You can even sometimes have verbal contracts that are accepted by action rather than by speaking. Contracts are much, much broader than anybody who's not a lawyer tends to think or realize. But sometimes you got situations that just do not meet the criteria for a contract. And one of those is WordPress. I'm not going to say the foundation. It's .org. Come on. Is .org saying, we've got the license so that everybody can use it? They're saying that really isn't enough to create a contract, I don't think. But there are doctrines, including unjust enrichment, which is another alternative one, and promissory estoppel. Yeah, basically for a contract, all the elements have to be met for a contract to get there. You have to have a sufficiently definite promise. You have to have offer. You have to have acceptance. You have to have consideration. If you don't have all of it, you don't have a contract. You might just have a promise that got broken. But sometimes it feels like a promise that got broken should be judicially enforceable. And promissory estoppel is one of those doctrines that covers that. In promissory estoppel, what you have is a sufficiently definite promise that was reasonably relied on by the other party to their detriment, which you have then broken. And the court will hold you to the promise in those cases. They will, it's sometimes called, now I forget. It's sometimes called quasi-contract, if I recall correctly. Implied contract, a contract implied in law. So Matt saying that employees can just be appointed to the .org, that's a business decision on his part. It's probably a bad business decision, but you get the right to make bad business decisions. But defendants have made promises that WordPress will forever be an open platform that encourages third-party developers, and the reliance was reasonable and foreseeable. Foreseeability of the reliance is an element some places, not other places. In reliance on those promises, they built a substantial business. And that is to their detriment because, they would have actually done a different business without the promises. They would have done a lot of things differently. Declaratory judgment of non-infringement. Yeah, they're not. I don't think they're infringing at all. Declaratory judgment of non-dilution is even... WordPress might be a famous mark, but if it's a famous mark, it's been diluted to shit and gone. Are not famous. And yeah, that's the thing is, I doubt, that, I don't know if it's a source indicator anymore. I don't want to say it's not a source indicator, but it feels generic. May not enforce rights on grounds of trademark misuse as it's attempting to leverage trademark law for anti-competitive purposes. 14 years of knowing acquiescence. Yeah. Libel is weak, but we already talked about that. You've got to probably prove the knowing... Yeah, and they're pleading it, and they might get there. Matt's dumb enough to leave a paper trail, but it's not the strongest of the claims. Trade libel is likely going to be the same. It's at least colorable. And I'd sure as hell, I would bring that with a straight face and a clear conscience. But I don't know that it's strong. The infringement claim was supposedly based on a study that said WP Engine had surpassed the threshold for likelihood of confusion with official WordPress. Yeah, you do that with... but the thing is, what's official WordPress mean? Is the thing there. And does everybody else also pass that threshold? You use surveys in trademark law a lot, but they've got to be good surveys. Slander is actually hard because it's got to be, documented speech. But my lord, he has made the swing at it. So anyway, yeah, they want judgments and they want damages. Yeah, and that's the thing. Can it be ubiquitous? So let's do basic. What a trademark. Yeah, let me use the camera that's not sucking. It's a shame. I like the not Elegoo. Elegoo makes one of my printers. Starts with an E. Don't remember who the hell makes the camera, but the last one was good. This one just seems to not be. Anyway. Elgato, thank you. Senior moment. I'm pushing 50. So let's do trademark basics. A trademark is really not a form of intellectual property in the U.S., or it's not supposed to be a form of intellectual property in the U.S. What a trademark is supposed to be is an indication of the origin, the source, or the sponsorship of the goods. If the word means the thing itself, it's not really a mark anymore. Famous example, because there are a lot of things that are kind of zombie trademarks that are hanging on by their fingernails, which are really generic, but everybody pretends they're not, and they're still valid on the books. Velcro. Prime example. Velcro is still a trademark of the 3M company. And the Velcro people have made some actually entertaining YouTube videos over the years asking people to, only use Velcro to refer to Velcro and to refer to everything else as hook and loop. And hooked fasteners. And what have you. I believe Kleenex is still valid despite the fact that every disposable facial tissue in the world is Kleenex. Here's a trademark for you that's great because it's generic in... Alright, so actually, I think this one translates to New Zealand too. There is something that is very generic in England, and I believe in New Zealand and Australia, that is still very much a legitimate, not even close to generic trademark in the US. I'm going to leave that one hanging, and I'm going to touch Hoover. Yep. Hoover is generic as hell in England. Every vacuum cleaner in England is a Hoover. Even though Dyson seems to make most of them these days. But in the US, if you say, I'm going to Hoover the living room, people are like, what, J. Edgar? Two countries divided by a common tongue. Not so much in New Zealand and Australia, thanks. Aspirin isn't actually the categorical example. The categorical example is Murphy beds. The bed you pull down from the wall. Tipex has never even been a thing in the US. It's whiteout. You know how long it took me to figure out that it's whiteout? Also, the first time I read Harry Potter, it took me until I'd lived in the UK for damn near a year before I realized that spellotape was a pun on something that's basically a generic thing over there that we just don't have the same word for here. But that's a total digression. Blue tack, fun tack, all that kind of stuff. WordPress, it's tough because WordPress has been distributed consistently. WordPress.org has been WordPress.org has been the primary repository. So I don't want to say it's not a source indicator, But to the extent that it's a source indicator, what is sellotape? Sellotape is Scotch tape. Also going for generic. The poor 3M company, man, they get screwed so often. Their products are too good. They genericide. WordPress has encouraged referential. Yeah, Linux isn't really a trademark, I don't think. It's never been treated as one, and you have to treat it as one for it to stay a trademark. Sellotape is Scotch tape. They are indistinguishable as far as I can tell, and I've used both. In fact, I think I've got rolls of both still kicking around because I pack rat that crap. But yeah, WordPress, I don't want to say that WordPress is generic, but it doesn't really feel like it's a great source indicator anymore. So I don't know. And it certainly feels like whoever it indicates source for, it doesn't indicate source for Automatic. I don't think there's a lot of people out there who hear WordPress and think Automatic. And Automatic may have had the commercial license, but they never seem to have exerted control over commercial uses. I don't even know if it's possible to have something be a trademark valid some ways and not others. It's weird. It is weird. But the basic point of a trademark is still to indicate origin, source, sponsorship. Not to be an owned property that you throw around like a ping pong ball. So I really don't know. It's really hard to say. Criminal, y'all got to go on Blue Sky and bug Popat. Sorry, Ken. If people go on Blue Sky and bug Popat too much, please. Sorry, Ken. But Ken White is a white-collar criminal defense lawyer. My understanding of criminal law is what I needed for the bar exam. No. The high watermark of my knowledge of criminal law was what I needed for the bar exam. I'm not going to speculate on criminal exposure for Matt or anybody else in this. That would be massively irresponsible. Other questions? I don't think we'll do 2 hours. Damn. Yeah, I don't think we're going to do the copyright on Broadway this week. We can save that for next week. That one's not going anywhere. What about the WP acronym? That one's I don't think there's any way that's a mark. Why do they need the injunction under federal law if they can get it under state law? They're in federal court. They've got both federal and state law claims, but they're in federal court with all of it. Genuine question. Does it need its own commercial sub-license if its parent company Automatic has a commercial license? I don't know their structure well enough to know. I don't know how separate WordPress.com is from Automatic to know that. If WordPress.com is just fully operated by Automatic, then it would be covered. And non-exclusive licenses for things generally don't need to be in writing anyway. Can the court decide to revoke the trademark? Courts really hate revoking trademarks, especially trademarks for stuff that is well known. That was one of the issues with, and one of the places where I may have gotten a little carried away with the stuff around the Hugo Awards last year. When you get to the point where stuff is well enough alone, the courts will try to make sure that it remains, protected and viable despite the best efforts of its owner. Since Matt owns .org, can it be reasonably considered that they're also suing .org? They're not suing, and that's the thing, they're not suing the foundation, so who the hell knows? Is the WordPress Foundation going to be a necessary party to this litigation? E- I don't quite think they are now. They might be for counterclaims. Does WP Engine have any cover given the fact that they changed around a lot of copy on their website after the cease and desist? No. That's not going to give them cover, but I don't think WPE has exposure. I think that, they're well advised to make changes just in case. That's a good precaution. But I don't think they got a lot of exposure. If they don't, yeah, and that's the thing, is that they've done a lot of non-enforcement. What can he reasonably get from them as the compensation? A reasonable license fee is usually the measure for trademark infringement. Could this draw attention from regulators? Yes. Probably it won't, but it could. Probably it won't. Other questions. For knowledge of a contract, do you need knowledge of a specific contract? Yeah, but they've got knowledge of a specific contract for everybody who takes them up on their offers. NDAs during severance packages. Big thing that happened today for Automatic employees. Did Automatic do a mass layoff today? On top of everything else? Does it make it harder to argue latches if there's a current sublicense? No, because the latches is in actually a lot of ways it makes it easier to argue latches, because the latches applies on a case by case basis, on a defendant by defendant basis. And when you can show that they had specific knowledge of these specific uses for over a forking decade, voluntary, a whole lot of people quit. Offered $30K or 6 months salary, whichever is greater. Buyouts, to anyone not aligned with the CEO's vision. The enforceability of any particular NDA is going to be a matter of employment law. If people know folks who are considering that, and California-based company, right? San Francisco-based. That's the kind of question where they should talk to employment lawyers. I know who I would send them to. I know who I would send them to. Almost 100 is the rumors. I'm behind on the thing and I'm scrolling up there. Anyway, DM me on Blue Sky or something if somebody knows someone from this who wants to talk to an employment lawyer, and I'll refer them. Drop the name in San Francisco right now for employee side employment. Rudy Axelrod or Outen and Golden. And we're working with them. I know people at both those firms that I'm happy to send people to. It's not going to be free, but if you want to make sure that you know what you can do and know what you can't do and everything else, and you can afford it, and you're talking about, $30K minimum, 6 month greater, then maybe you want to think about dropping a couple $1,000s to make sure that you're well protected. That's not the kind of work that our firm does routinely. But for California folks who are considering that, message me on Blue Sky, and I'm happy to send you to the lawyers that I know at those two firms. More than happy to. Deadline was today. Okay. 150 resignations. Austin's where they're theoretically based, but they're remote first, so it depends then on where people are. But for California, absolutely, I know folks. Important question, Hot Pockets. I'll get to that in a second. Fake self-employed working for Automatic Worldwide. I don't even know. Yeah, employment law is not one of my usual areas. Contract more. One Star Wars Attack of the Clones or Empire Strikes Back. Honestly, man, the comedic levels here have Naboo vibes. Does my firm do trademark reg? Yeah, we do trademark reg. I do trademark reg and I do it flat fee. Let's see. 4.5 million bottom number. Trademark law or WordPress development for your next gig. I wonder that myself, except, I flunked, yeah, here's my tech background, y'all. I know enough tech to be dangerous to myself, okay? How many people are going to self-describe in here as software engineers or programmers or coders? Because I will ritually humiliate myself right now with how I got out of computer science as a major in 94? No. Was it 4? Yeah, it was the end of fall semester of 94. Almost 95. In my defense, in 95, you had to compile, all right? Like you had to get your shit to compile. What killed me was the midterm for the Computer Science 201 Intro to Programming Pascal class. 18 hours trying to get the program to compile. 18 straight hours on a VT220 on a VAX trying to get the midterm assignment to compile. And at midway through hour 18, which was at 3 in the morning, Peaceman, Saj Ahmad, who dreamt in code, walked behind me, looked at my screen, and went, semicolon. "18 hours. I would say cult-like organization is opinion, but consult your own lawyer if you are in doubt. That would be legal advice. I would personally not be sad to call them that. And yeah, prior to the 2000, I was trying to compile this on a VAX. I tried to compile it so many times that I ran out of allocation and had to go to the had to walk to the help desk to go get more allocation. But anyway, after a long, circuitous path, I wound up in tech law instead of tech. I would probably be more financially well off if I had stayed in tech rather than tech law. What can you do? Anyway, y'all, it's been a long stream. It's been a ride. Thank you all new people for coming by. For everybody, the election's coming up. I'm sure we're going to be hitting to. I'm sure we're going to be heading to some political and election-based stuff, but on the whole, I actually really want to start shifting the stream more toward tech and IP law than I've been for a while. As we've had more cases coming up, I've been enjoying getting back to those roots a little bit more. Other thing for the new folks, in addition to the tech law, I also did a PhD in fan fiction and copyright at Queen Mary University of London a few years ago. Grab it with the third party. I'm going to forget, and I've got stuff that's going to take me until the point I forget. But I would say expect me to be doing more tech law. Also, I think I'm going to be sticking with the Aloha shirts. I mean, I've been doing t-shirts, but I feel more work if I'm wearing a work shirt. So, yeah. Anyway, until the next stream, which will be next Thursday, same time. 150 with more time on their hands, yeah. I gotta say, 150 people voluntarily unemploying themselves in this tech economy is impressive. Would I be fine with UK cases? Yes. The only caveat with UK cases is that it's harder to get the pleadings. So it's harder to comment, but yeah, absolutely, I'm comfortable with UK cases. Thanks. I mean, it's Rain Spooner. It's hard to look bad in Rain Spooner. The executive director of the .org software quit. Nice. Yeah. That guy is really trying to kill a lot. But anyway. Until the next stream, my name's Mike. I'm still a lawyer. I'm still not your lawyer unless I am your lawyer. And again, we've talked about this. And others. Do not take any of this. How hard was it to shift from computer science to law? Avenir, I went from computer science. I went from computer science to soft science, lab tech, through evolutionary biology, and then into law. So, remind me some other time. It's been a long, circuitous path. I was an EMT while I was in college, so around the same time, at the same time. But yeah. But yeah, no, I have lab tech for paleontology, and I've done evolutionary bio and stuff. I'm not a K to JD. Not that there's anything wrong with being a K to JD, and I don't just say that because my boss is a K to JD. But tech to law is pretty, interesting. Anyway, you guys have fun. For those of you who've been following me on Twitter, follow me on Blue Sky. I'm there more. I'll probably get bored with this on Twitter within a couple of days and not be checking Twitter more than every 2 or 3 days. Blue Sky I'm on the regular. But till next time. Oh, dog. Kapua, come say goodbye to the peoples. Yes, say goodbye to the peoples. That's a good dog. Just keep your breath away from my nose. Good dog. Yes. All right. Good night, everybody. Mike, still a lawyer, still not your lawyer. Mahalo for watching. And aloha.